As we now have a quorum, the committee is in public session. This meeting has been convened to resume consideration of the Legal Services Regulation Bill 2011. Apologies has been received from Deputy Alan Farrell and Deputy Fionnán McGrath. Deputy Mick Wallace will substitute for Deputy McGrath. I'm also advised that Deputy Paddy McLaughlin may need to be absent from part of the meeting. In his absence, Deputy John O'Brien will substitute. Could I have agreement that we take a break from 11:15 to 11:30? Short break, there's a request for that. And we will work then until almost 1 o'clock. We'll see how we get on there after that. I would like to welcome the Minister and his officials to the meeting. Please turn off all mobile phones, everybody, as these phones actually cause a problem with the sound system. So I will now turn to section 71 of the bill. Section 71, there's an amendment there in the name of Deputy McGrath. Acceptance of this amendment will involve the deletion of section 71 of the bill. This is a new section. 153, 154, 156, 170, 171 are related. 155 is a physical alternative to 154, 153 to 56 inclusive, 170 and 71 will be discussed together. The section is, I know, opposed by Deputy McLaughlin. Now, so I note that Deputy McGrath isn't here, so he can't move 153 and 154 and 156. So 170 and 171 are in the name of the Minister. Minister, to discuss those, please, at this stage.
Very well.
170 and 171.
Just give me a moment to tune myself in. This is yes, we're not dealing with anticipation, Chairman, of Deputy McGrath's and others. I'm just trying to find. So this is
170 and 171.
Just bear with me a minute. There we go. Now, it's a pity that we have absent friends, but there we are. Government Amendments 170 and 171 provide that the authority will engage in two separate public consultation processes under sections 86 and 87 respectively, rather than the one consultation process which the published bill had envisaged. Under section 86, the authority will engage in a consultation process with regard to the regulation, monitoring and operation of legal partnerships and MDPs. This consultation will feed into the exercise of the regulatory power of the new authority regarding business structures. It's envisaged that the authority will conduct the initial consultation process within 6 months following its establishment and not within 18 months, as in the published bill. The report of the Section 86 public consultation process, once completed, will be presented to the Minister, who will have it laid before the House of the Oireachtas. The Minister will also at that time furnish the report to Cabinet along with details of the proposed date of commencement of legal partnerships and multidisciplinary practices provided for under Sections 72 and 74. Section 86 also envisages that the authority may carry out other periodic consultations on the regulation, monitoring and operation of legal partnerships and MDPs or multidisciplinary practices. The authority under Section 87 will carry out a separate public consultation process in relation to the manner in which a barrister may hold clients' monies and whether the current restrictions on barristers receiving instructions on a contentious matter directly from a person who is not a solicitor should be retained or removed. This consultation process is now to be completed within 12 months of the establishment of the new regulatory authority. The bill, as members will know, originally published prescribed a period also of 18 months. With the relevant report to be laid before both Houses of the Oireachtas by the Minister within 30 days. Could you take page 4?
Right. Deputy McLaughlin, do you want to come in on You're supposing the section.
Yeah, it's going to be, sorry, through the chair, it's going to be somewhat problematic because I have indicated that I am opposed to the entire part and the principle of MDPs, but I will deal with my opposition in block to it also, and I'll deal with, for example, some of the Law Society's points in relation to this. Minister, can I take the opportunity to indicate why I'm opposed to the MDPs and the part at this stage, or should I deal with the specific section? I will, yeah. Minister...
We'll be putting the section later anyway, so if you want to take the opportunity, you can do that.
Oh, okay. Well, basically, just to say this, that I don't understand why you have gone in this direction and sought to introduce this these range of sections. I don't know why you're going down the road of business structures, multidisciplinary practices. I just want to note that MDPs involving lawyers are not permitted in the following EU countries: Bulgaria, Czech Republic, Cyprus, Denmark, Estonia, Finland, Greece, Hungary, our own country at present, Latvia, Liechtenstein, Lithuania, Luxembourg, Malta, Netherlands, Poland, Portugal, Romania, Slovakia, Slovenia, Spain, Sweden and Scotland. And, you know, there's just... I just don't know the rationale. I mean, the issue around, you know, what's supposed to have driven this bill was the Troika and the need to reduce costs and, you know, certain sectors of the Irish economy being too costly and so on. You know, this doesn't, in my view, address that. The other point then is in terms of the regulatory impact analysis carried out, you know, in relation to this bill. It does not include any analysis of the proposals to introduce the MDPs, and it makes assertions that aren't backed up by the evidence. Another important point, the Competition Authority itself, the report that was supposed to be leading up to this bill, didn't recommend MDPs. The regulatory impact assessment refers and cites Scotland and New South Wales as some examples of jurisdictions that have them. But what it fails to do, mention that, which is a critical point, barristers are not permitted to participate in MDPs in those areas. A concern I have as a Donegal North East TD and a rural TD in the main is that one of the benefits of the current situation is that you can go to a solicitor around a range of challenges you might face in your nearest town, and that solicitor can access the service of the best placed person within the Bar Council. So you have that selection and that option at the moment as a person living outside the main urban bases. The difficulty in what you're suggesting is that the best and brightest could be sucked into these sort of corporatised structures. Now, I think for a state of 4.5 million, I just don't understand the requirement, you know, in terms of the allegations of economies of scale, why this would be needed at all. There's then the issue of, you know, the legal practitioners themselves and indemnity. There's a whole need for clarity around, you know, if you have this multidisciplinary practice of, you know, a practicing legal practitioner and others, there's a whole question mark around liabilities. We've seen in other jurisdictions the difficulties that arise when you have a range of people covering a range of bases, and you know, the Enron scandal is one example of where you have people who are supposed to be doing audits who are also involved in consultancy. So I really don't know why there's a big drive for this. I don't know what the demand. I mean, the phrase "one-stop shop" sounds good, but it's a one-stop shop for big business. It isn't a one-stop shop for Charlie Joe up in Donegal, or Mary in Galway, or Mickey down in Tralee. You know, so who are looking about, you know, some sort of a health issue or some sort of a financial issue or a family law issue of complication. So I have to oppose this part in its entirety. I have to say, I think there's been very little detailed research done I see that you talk about, I know it's a compromise that clearly arises from the differences in Cabinet, that you're going to go out for consultation around this, but looking through the concerns of the Law Society and the Bar Council, just having an objective analysis of what they have to say in relation to the current state of play and what you're proposing, I think you take the current state of play any day of the week. The other difficulty I have is that this bill, one of the primary objectives we understood out there was it would reduce costs for people. And frankly, I think the mediation bill, as I've said this to you in the Chamber, Minister, on numerous occasions, I think the mediation bill later in the year will actually do more to reduce costs than this bill does here. So, I mean, I don't know what the public interest is in moving forward with these multidisciplinary practices, I have to say. And I'll just speak in more detail, dealing with the concerns of the relevant stakeholders as we move forward. I just want to put on the record that it's not just the Bar Council. The Law Society have a whole range of concerns around indemnity, around clarification, around the types of practicing solicitors and their background, the issues of what are the other partners, what is the definition. They've got a range of recommendations which they have submitted to you, Minister, and to my committee, but also the free legal advice centres, the Northside Community Law Centre, Irish Congress of Trade Unions. There's a whole range of stakeholders who are telling us that we should oppose these MDPs. The other issue is, in a corporate structure, a barrister would become answerable to many others, including shareholders, other partners, boards of management, high-paying clients and so on, giving rise to a real risk that the best interest of the clients and the courts will no longer be the priority. There's also a real risk that, should such corporate structures be introduced, the market will substantially contract, allowing only the largest firms access to the best of the bar, thereby substantially transforming the character of access to justice for all of the citizens of the state. Similar to football leagues, the biggest firms with the deepest pockets will hire the best players and charge fees out of the range of all but powerful big business interests, leaving the ordinary workers outgunned on every occasion. So, and then the reduced opportunities to devil, that phrase for barristers who are, serving their time and moving up through that ladder of experience. There's a whole range of issues, but I just wanted, that's my initial statement to you, Minister, around my concerns, and we can probe through other issues as we go through the sections.
Okay.
Sorry, sir, apologies.
Thank you. Minister, do you want to respond there?
I do, Chairman. Let's talk about multidisciplinary practices and what's involved. Can I say, to start off with, I'm very disappointed in the contribution by Deputy McLaughlin. I don't mean it in a personal sense. I thought his party presented themselves as being interested in reform, not in maintaining structures in the state we've had for over 100 years, nor indeed representing vested interests within the legal profession. His contribution in referencing what essentially is the Bar Council brief reflects the Bar Council's logo approach, nolumus mutare, no change. We're living in a different world to the 18th century, and what this legislation is about is not to serve the legal profession, but to serve the general public, and to ensure that people have access to legal services, that there's a wide range of business structures through which legal services can be provided, that lawyers who are practicing have options as to how to provide legal services and earn a living, and that regardless of the mechanisms through which legal services are provided, there's appropriate regulatory provisions in place and independent oversight. There's nothing about the one-stop shop or the multidisciplinary practice that is so uniquely complex as to make it impossible that there's appropriate regulatory oversight. Nothing that makes it compulsory that any individual legal practitioner, barrister or solicitor, provide their services through multidisciplinary practice. We have a legal system at the moment whereby solicitors can be sole traders or they can be partners, and you can have small firms with 2 or 3 partners and large firms with 50 or 100. Sorry, Karen, I think this thing isn't off. Or large firms with 50, 100, 200 or more partners. The large firm argument about this is not me. The large firm argument about multidisciplinary practices will suck up all the good lawyers. Well, have the big legal firms, the big 5 in this country, sucked up all the good lawyers? Are there any good lawyers anywhere outside the big 5? Of course there are. There are good lawyers across this country practicing in a broad range of areas, some general practitioners, some engage in niche specialties. Some lawyers like to practice in big firms, some lawyers like to practice in small firms where they're solicitors, some like to practice as individual sole traders, some with partners. Where they're barristers at the moment, they're all effectively individual sole traders. They can't operate in partnership, though some of them have taken to acquiring premises together in which they have offices and out of which they share the expenses, but they can't share fees. And then you have some parts of rural Ireland who don't go near the Bar Library at all, and who, to all intents and purposes, are operating a legal practice, but they can't advertise it as such. We have a whole range of restrictive practices. Then we have the general public. Many members of the general public who have legal issues need to get advice on financial matters, maybe other matters. They may need to visit their lawyer, visit their accountant, possibly visit their surveyor or engineer, or they may need other assistance. And they're paying money. So the lawyer writes to the accountant who writes to the surveyor, and they're going and having individual meetings with all of them, and they're incurring unnecessary expense. And the attraction to members of the public, where you have a particular type of legal issue on which you need assistance or advice, if you have a one-stop shop, is maybe you can meet them all together. Maybe they'll actually talk to each other in the one room. Maybe you won't have to pay for multiple consultations, or indeed for people who should work together to send letters to each other. So this is about public interest. It's about understanding that the manner in which our legal system has developed is a historical accident. Our legal system didn't develop based on any great plan. It developed to reflect the manner in which the legal system developed in our colonial days in the United Kingdom, in England, as they went through the 17th and 18th century, and divisions were created between barristers and solicitors, and formations were created. And then Ireland differentiated itself, because in England barristers can have chambers, and in Ireland in theory they don't, though in practice some of them, to all effect, are now operating through chambers. Multidisciplinary practices are working, for example, in New South Wales. And what we're doing is looking at options. Now, the difficulty is with a conservative profession, and the most conservative wing of that profession is the bar. Everything is seen as a threat. Everything is seen as being malevolent. Nothing is seen as being in the public interest. Now, there are a myriad of young barristers in this country who can't get work at the moment because they're dependent on the goodwill of their seniors or their relationship to some solicitor or some senior or long-standing junior counsel to be able to feed themselves, but have enormous legal skills. Is there any reason why they shouldn't be, for example, simple employees in a solicitor's firm for a number of years and apply their legal skills there, with the option, if they want to in the future, to be single operators in some specialist area? In what way is that contrary to the public interest? May be disruptive within the reams of the bar, but in what way is it contrary to the public interest? I can't identify a public interest problem with that. Is there any particular reason why, if you have solicitors and barristers working together, for example, in a practice, or barristers operating truly as partners in the sense that not only do they share the premises and the expenses, but depending on the luck of when fees are coming in, they may share the profits and their fees. In what way does that create a public interest issue if there's appropriate regulatory oversight and the principles prescribed by the legislation to which members of the legal profession must adhere are in place, and a failure to adhere to them could result in a disciplinary intervention? What we're trying to do is provide options. Now, just as in the context of the bar and the solicitor's profession, I have absolutely no doubt that following the enactment of this legislation, when MDPs are established, for many years, a majority of lawyers will continue to operate within the legal business structures that currently exist for lawyers. But some will choose to do it differently. Where they do, it'll be to the benefit of the public, and it'll generate competition and insights, and will ensure those with particular skills can utilise them, and the professions can actually work together. Why is it that we think a one-stop shop in other areas of life is a very good idea, but in this context it isn't a good idea? Now, I want to come to some of the specifics here. The Competition Authority in its 2006 report observed as follows: the ban on the formation of multidisciplinary practices prevents the supply of interrelated services together in a way which may generate synergies known as economies of scope, prevents professional service providers from catering for clients with a set of interrelated needs, and from integrating their supply with providers of complementary services. Went on to say that, and I quote, the prohibition also limits the ability of clients to benefit from a one-stop shop, hinders innovations which might otherwise result from the combination of different services, and which would allow for new products or services to be developed to the benefit of clients. Now, the Legal Services Bill addresses that. If we look across the water to the UK, legal services are now being provided through a whole range of alternative business structures, including the co-op movement. Why? To provide readier access to the general public to legal services at lower cost, and to provide that access through different locations, maybe high street locations rather than high-end office locations. What are the benefits of multidisciplinary practices to the legal profession? Well, if you're a small, for example, solicitor's firm operating in a rural part of Ireland, and you have up the road to you a small accountancy firm operating, and you're constantly interacting with each other because you're serving the same area with largely the same clients, why shouldn't you be able to operate a single business providing that service and the synergies and complementarity that comes along with it? Now, on the disciplinary issue, the context of having a strong regulatory framework, an independent legal services regulatory authority and appropriate codes of practice, there's no difficulty or mystery how you ensure that the appropriate ethical principles and obligations of lawyers are complied with, including the lawyer's obligation as an officer of the court to behave in a particular manner. Now, Deputy McLaughlin recited the bit that comes directly out of the Bible, the Bar Council's submission, about barristers being, and they don't phrase it this way, but the implication is barristers might be sort of corrupted by having to ply their trade within a corporate structure. I have more faith in the ethics of members of the bar than that. They will be required to continue, any barrister who may, at the end of this process, find themselves in a position where they're part of a multidisciplinary practice, will have to comply with the legal ethics and principles prescribed by the legislation, with the appropriate codes of practice that are in place, that are consistent with the legislation, not the restrictive codes that currently exist to provide a block on how you provide your legal, how you sell your legal services. And should they fail to comply with the ethical requirements, what will happen? If there's misconduct, we'll have an independent process to adjudicate on that. Now, Enron is mentioned. This is one of the great myths that is of some relevance to this particular issue. Enron's of no relevance to this issue at all. The circumstances that led to the problem with Enron have nothing to do with the existence of multidisciplinary practices. The failures of Enron were not related to the conduct of lawyers, but rather a corporate governance and accountancy failure of regulation. That's the absolute key. The Enron problem arose in relation to a large incorporated publicly quoted entity with a range of different business areas and subsidiaries and associated companies. The overall Enron entity, to which the share price was pinned, managed to portray itself as profitable in circumstances in which clearly was not, and it inflated its share price on the markets. the same time, it used various accounting devices to hide what were in fact large-scale losses. It did this through the use of the accounts of its subsidiary and regional operations. It appeared that the accounting firm, which was the Enron auditor, was at the very worst either complicit in the accounting devices of Enron or, at the very best, was negligently oblivious to them on an extraordinary scale. However, the source of the problem was not the professional conduct of lawyers, but accountants supervising the accounts of a corrupted corporation. So I don't know why Enron is brought into this, other than as some spectre to hang over of a threatening nature to indicate that if we have multidisciplinary practices, everyone will be automatically corrupted by the very existence of the structure. In the context of Enron, the issue of the relationship between the Enron case and MDPs is very interestingly and specifically addressed by Paul Patton in a 2010 article in the Fordham Law Review, in which he says the following, and I quote, "If accounting firms were willing to sacrifice audit integrity in order to secure more lucrative consulting arrangements, the argument went, then certainly lawyers working for MDPs controlled by accountants would be pressured to compromise their integrity and independence for financial gain. Such a position, however, fails to acknowledge one hard truth. Enron resulted from the improper behaviour of many professionals, including lawyers, acting in separate accounting or law firms." I emphasise this. The lawyers were acting in separate law firms, not in MDPs, rather than from an inherent flaw in multidisciplinary practice arrangements. Rather than pointing to Enron as a justification for banning MDPs, regulators and others should instead consider how best to structure incentives for the ethical behaviour of lawyers and others within all professional service firms, whatever the configuration of the firm, so regardless of the construction of the firm. Simply banning outright a business model for delivering legal and other professional services fails to address the more complex question of how best to reward independent, ethical and candid advice, regardless of the conduit through which that advice is delivered. What we envisage is ethical, independent and appropriate conduct with a sophisticated regulatory oversight independent of the legal profession. There's nothing the Deputy has said or presented which indicates that there's a public interest reason for not proceeding with multidisciplinary practices. Indeed, all of the arguments are a public interest reason for doing so. The Deputy has cited what exists in other parts of Europe. We recently passed our insolvency legislation. And in other parts of Europe, there isn't a precedent for the personal insolvency arrangement, which allows arrangements to be entered into between debtors and creditors to resolve debt in circumstances where there's secured debt. We've set a precedent in that. I'm proud of the fact we've set a precedent. The existence of that provision in our legislation is now forcing financial institutions to enter into arrangements without debtors having to engage in the personal insolvency legislation's formal structural approach, because they know if they don't so engage, they may be forced to do it under the personal insolvency arrangement, or if they don't cooperate in that engagement, the option of bankruptcy, with a very limited term of bankruptcy, may be sought. What's happening in the rest of Europe at the moment? The rest of Europe is looking at our insolvency legislation and talking about replicating it. One of the officials in my department, who is principally responsible for helping draft that legislation, is currently, at the request of the European Commission, assisting in drafting similar insolvency legislation for another European Union state. I don't mind if we're a trailblazer on the Legal Services Bill in dealing with an appropriate provision to establish multidisciplinary practices to the betterment of the general public accessing legal services. But I don't accept what is suggested in this regard. There's no member of the Bar Library, for example, who will be compelled to join a multidisciplinary practice. There's going to be a lot of members of the Bar Library who have niche expertise in their individual areas, who will want to continue to work as they do, with the option of being recruited by individual solicitors when there are clients in need of that niche expertise. There'll be areas of work where you couldn't possibly simply join a solicitor's firm because the individual firm wouldn't have the volume of work that would justify employing you on an annualised basis as opposed to for an individual case. But there may well be circumstances where solicitors and barristers may work together to the benefit of their clients and to the benefit of their own business arrangements, in which members of the bar will join in. But I don't understand the fear that exists within the bar on that issue. Now, the Deputy has raised some issues that are important issues in relation to the Law Society. It was always the provision in this bill that in advance of the creation of multidisciplinary practices, the Legal Services Regulatory Authority would engage in a consultative process so as to ensure that the correct, any regulatory measures that need to be put in place or any codes of practice that need to be put in place would be considered and put in place, that we would ensure that they had the insights they needed for anything that may need to be done in the area of financial oversight. And what we're doing at committee stage is we are, as we go through it, tidying up provisions in the bill based on where we got to some weeks ago. I, because of my interest in this bill, am very interested in all the submissions we've received, and I've taken very careful attention of them. And indeed, the Law Society have made some very constructive and suggestions for fine-tuning the bill with regard to some regulatory matters, which we will be taking on board at report stage. And very recently, because I'd have received a submission from the Law Society following on a publication, Chairman, of the amendments we're dealing with today, which raised some issues. And this is why this consultative process is so important, because we're dealing with a new area, and just as the consultative process helped to improve the insolvency bill, the consultative process will help to improve this. But I'm going to conclude on this note, which is saying that it is disappointing that a party that presents itself as reformist in the context of this bill is simply presenting the arguments of those who are utterly opposed to reform, particularly opposed to changing anything with regard to the manner with how legal services are delivered, opposed to apparently giving the general public greater access to legal services should they require them, giving the public greater access to the possibility, and I emphasise possibility, that the cost to legal services may reduce if there's greater competition. And also cutting off the possibility for members of the legal profession who are qualified, who are ethical, and who are well trained, providing legal services through alternative business mechanisms in a manner that might produce economies of scale, in a manner that might reduce their overheads, and in a manner which will enable them to pass the reduction in their overheads onto clients by way of reduced costs.
Okay.
Yeah, sure. I have a number of our issues. Minister, just for the record, you referred to the Bible of the Bar Council in relation to responding to a couple of quotes. The Bar Council were pleased to learn that they're now in the hallowed company of the Irish Congress of Trade Unions. The references you made came from their submission, so the Bar Council and the Irish Congress of Trade Unions are now in a conservative camp together, apparently. In relation to vested interest resisting change, I don't think you could include the Irish Congress of Trade Unions, the Free Legal Advice Centres and the Northside Community Law Centre in that category. So I just would say, Minister, I respectfully disagree with you. I would defer to your greater knowledge of legal matters and all of that. But I think we need to keep the debates in relation to, there are a range of people, you would argue some conservative, I would certainly argue others very, very progressive, who have legitimate criticisms and concerns around the MDPs and these business partnerships. And we are clearly not going to change your mind on this, but I would just say to you that if you're going to go into the consultation process and you're going to go down that road, there are many legitimate criticisms from a range of stakeholders, including some of those vested interests and others, the vested interests that you would refer to. I would ask you, if you're going to go down this road, to listen to all of the constructive criticisms that are there and try to put in as many protections as possible to deal with the legitimate concerns that have been put to you. So you're the minister, you get to make the law along with your majority in government. But I would only say to you that you would hear constructive criticism and try to strengthen it if you are going to go down that road. That's all I would ask, Minister.
Can I invite Deputy Collins? You have an amendment. We are dealing with 155 as well here on this group. If you want to speak to that.
Thanks, Chairman. My apologies for being late to everybody at the meeting. Minister, I didn't hear your introduction to your introductory speech entirely. Can I just ask you in relation to multidisciplinary practices and alternative business structures, have you received conclusive proof that it will move legal costs in a downward direction, that it won't result in inflation of legal costs to the consumer? Secondly, in terms of, you mentioned competition, is it not the case that if you have a number of NDP structures that and they manage to corner the market with a number of the specialists of a particular field or of a particular area, that could potentially lead to price inflation, or it would lock out people from availing of the choice that may be out there at the moment in terms of trying to tap into those people's services. I think that's the main problem that has been brought to my attention in relation to MDPs. In relation to the alternative business structures, is it right, is my understanding right, that the alternative business structures, that you could have non-legally qualified people then providing the legal service? Is that what we're seeking to have, that you would have people who wouldn't be qualified to practice either at the bar or solicitors themselves, that they would potentially be involved in providing through a mechanism legal services to the consumer? Thanks.
Thank you. Minister, do you want to respond to those two speakers?
I will, but I'll do it briefly because we've explored a number of matters already. I don't understand, Deputy, how if you have...
Speak to the Chair, Minister, please. Beg
your pardon, Chairman. I don't understand Deputy Collins' question as to why he thinks if you have a new alternative model through which legal services can be provided, that it'll all be concentrated through that one model. I mean, on that theory at the moment, you could have expertise. You could have a number of a small number of solicitors firms who only have expertise in particular areas. The existence of an alternative structure through which to give legal advice doesn't of itself create a monopoly of expertise in a particular legal area within that structure. I mean, I just don't understand that argument, and I don't know where it's coming from. The purpose is that you will be able to access legal advice through alternative business models. At the moment, if you, for example, visit a solicitor's firm, you will consult with a solicitor. You might, in some instances, meet a legal executive who the solicitor might authorise to talk to you about something, but if you go and talk to the legal executive, if the legal executive is engaged with you, you would expect to be under the supervision of the solicitor. There isn't a suggestion you're going to create multidisciplinary practices in which there's a whole range of individuals who have no legal qualification pretending to be lawyers, because that wouldn't be the way this should work. And there's an interesting issue. I think the Law Society in their recent amendments suggested some small amendment might be made to the legislation to provide a protection in that regard. And again, I very much appreciate the constructive engagement that we're having in that context as we tease through the bill. So no, there's not a suggestion that you can create multidisciplinary practice and then throw up a whole series of unqualified people who pretend to be lawyers and give people advice, any more than if you have a solicitor's firm who throws up a whole range of unqualified people who pretend to give people advice and don't have the qualifications to do it. There's no particular reason why that should emerge any more out of multidisciplinary practice than out of a solicitor's firm. And if you have the correct regulatory structures in place, it won't. But of course, a multidisciplinary practice like barristers or solicitors will probably employ non-lawyers as secretarial assistants and people to do other works and backup work. That's part of the way the law has operated for a lot of years. Now, I don't understand why the creation of multidisciplinary practices should make it more expensive to get legal advice. One of the great things also about human beings in different walks of life who have expertise is they want to ply their trade. People think, lawyers, and one of them on occasions likes to think, that what we do is terribly mysterious, that we do something that's so mysterious that the rest of the world doesn't understand it. Whether you're a lawyer or an engineer or a doctor or a plumber or landscape gardener, what you're doing is you have an expertise in your life and you sell that service to assist individuals who need it, and you earn a living by getting paid for what you do. It's no more mysterious than that. And there's no and providing an alternative mechanism through which you can deliver legal services simply is what it says on the can, an alternative mechanism. The world, strangely, hasn't collapsed in England with all of the reforms that have been introduced in the last 3 or 4 years that members in this House, and indeed the general public, and indeed the legal profession in Ireland, seems to be oblivious to. An hour's flight away, there's a revolution taking place in the provision of legal services. But what's interesting about the revolution is it's still only a small proportion of practicing qualified lawyers. It's only a small proportion of the business mechanisms through which legal services are providing who are using the new mechanisms. They're there, they're being used, they're providing opportunities, and they're providing legal assistance and advice. But because lawyers, many of them are happy with the economics and the architecture of the way they've been doing business in the decades past, haven't changed. But we're providing the opportunity for change and evolution. What's finally, Chairman, really interesting about this, there's a marvellous book written which is entitled The Regulation of the Legal Profession in Ireland by one Maeve Hosier. It's a PhD thesis that she's done. It should be compulsory reading for all of us. It gives the history of the legal profession and how it evolved. It continually evolved until about 1870. Then it went into paralysis, and nothing has changed since. The only thing that changed since was the Courts Act of 1971, when the then Minister for Justice, Des O'Malley, conferred a right of audience on solicitors in all of the superior courts. That's the only fundamental change effective since about 1870 to the manner in which the Irish legal profession operates. And it's extraordinarily curious as to why people think the world stopped in 1870.
Okay.
There's one more brief question I have. Sure. Minister, I understand that you've indicated that you would deal with the issue of limited liability partnerships in report stage. While we're on the subject of reform and modernisation, that would be something of concern. Can you just indicate what you intend to do around that?
We'll be bringing forward amendments on that particular matter. It's an issue that has arisen over the years in other legal systems. It's possible for a legal service to be provided through limited liability partnerships, but it requires ensuring that there's client protections available, that commitments to maintain indemnity insurance are complied with, the commitments to, for example, if it's in the context of solicitors, that payments are made to the compensation fund. We're working on that particular area in the context of the required amendments, and there'll be, of course, Chairman, every opportunity to discuss them at report stage.
Okay. Well, okay. We'll start off so with the Amendment 153 cannot be moved. Deputy McGrath is not here. On the Section 71, I note the section supposed by Deputy McLaughlin. The question is that Section 71 stand part of the bill. Now, do you want to speak to this section, or have we teased it through enough?
Yeah, no, all I want to say is I reserve the right to put in amendments later under Section 71.
Okay. So the question is that Section 71 stand part of the bill. Is that agreed? Agreed. Section 72, Amendment number 154. It can't be moved. The Deputy is not present. Amendment number 155 in the name of Deputy Collins. Deputy Collins to move. The question is, it be made. Is that? How stands the amendment?
Press.
The press the amendment. Okay. On amendment number 155, the question is that the amendment been made. Those in favour say tall. Those against say nil. I think the amendment is lost. Amendment lost. The next is that's under section 72. I know the section is opposed by Deputy McLaughlin. The question, how the section?
I just indicate I reserve the right to come back with
Right.
detailed amendments in the report stage.
Question is section 72 stand part of it. Is that agreed? Agreed. Section 73, amendment 156, the deputy is not present, it's not substituted, so again that cannot be moved. Section is opposed, section 73 stand part of the bill. Deputy McLaughlin, how do you say?
Again, I just indicate the right to come back with amendments.
So the question is that section 73 stand part of the bill. Is that agreed? Agreed. Section 74, Amendment 157, in the name of the Minister. Acceptance of this amendment involves the deletion of Section 74 of the Bill. This is a new section. 157, 158, 167, 168, 169 are related and will be discussed together. Minister to move.
Sure. Where are we on this now? Which number is this? Yes. Yes. No, that's fine.
One 157 of which other amendments are being done?
157, 158, 167, 168, 169.
167, 168, 169.
They'll be discussed all together now.
Now, Government Amendment number 157. Firstly, Section 74 creates the basis for multidisciplinary practices by providing that a professional code shall not prevent a legal practitioner from providing legal services as a partner or employee of an MDP. This section was originally contained in Section 74 of the published bill, which also contained a number of other provisions relating to the role of the managing legal practitioner in a multidisciplinary practice. The role of the managing legal practitioner has been further developed. It's now set out in Section 77. It should also be noted that Sections 72 and 73 of the published bill and the definitions in Part 7 remain unchanged. Amendments number 158, 167 and 168 are part of a cluster of amendments which provides a series of regulatory safeguards with regard to how legal services will be protected in MDPs and how consumers will be protected. Amendment 158 deals with notification of commencement and cessation. Under Section 75, an MDP is obliged to notify the Legal Services Regulatory Authority, or the LSRA, of its intention to commence or cease the provision of legal services. This section is based on a similar provision in the legislation on MDPs in New South Wales and will ensure that the LRSA must be informed of the existence and operation of all MDPs in Ireland. I now turn to Amendment number 167, specify measures. Section 83 provides that the LSRA, or the Legal Service Regulatory Authority, may issue directions to the managing legal practitioner or to the practice where it's satisfied that the provision or regulations made under this part are not being complied with. Section 83 also provides that the MDP, or the managing legal practitioner, may appeal a direction of the authority to the High Court within 21 days. In such cases, the High Court may confirm the direction of the authority or revoke or vary the direction. Now, Amendment number 168, application to High Court to suspend or cease providing legal service. Section 84 provides that the authority may apply to the High Court for an order requiring an MDP or managing legal practitioner to comply with the direction. These powers escalate up to and including seeking a direction of the High Court that the MDP cease provision of legal services. Amendment 169, Section 85 now provides that the Legal Service Regulatory Authority shall make regulations with regard to the operation and management of a legal partnership or a multidisciplinary practice. As previously mentioned, the authority will engage in a public consultation process under Section 86 with regard to the regulation, monitoring and operation of legal partnerships and MDPs. This consultation will feed into the exercise of the regulatory power of the new authority regarding business structures. What we're dealing effectively with, Chairman, is the important regulatory oversight provisions which I referenced in my earlier comments with regard to MDPs, to ensure that, as with other structures through which legal services are currently delivered, such as solicitors' practices, sole traders or partnerships, to ensure the appropriate regulatory oversight and the appropriate regulations are ultimately put in place following on from a consultative process.
Okay. Nobody offering on that? Okay, I'll put the question then. The question is that Amendment 157, that the new section be there and stuff. Is that agreed? Agreed. Now, the section is opposed by Deputy McLaughlin. Deputy McLaughlin, now there's a change here now, which is unusual because Section 74 stand part of the bill and it's not going to happen. So I'm not sure how you can oppose something that's been changed. So
Section 74.
it's a new Section 74. So
We just do this deliberately to confuse you.
so so it's a little bit convoluted there.
Well,
So
there's only a couple of other additional points I want to make later on.
All right.
So I'm going to just indicate my right to
Come back,
the new
yeah.
section
Okay.
or the
we've
deleted
got to look at
section.
the new section, so they've moved the section. So that's the question is that Section 74 stand part of the bill. I know the decision should be in the negative. At least that's the expectation. Neil, agreed? Question is lost. Okay, Section 75.
Could I just speak on section 74/75 for a moment?
Sorry, now we've just decided Section 74.
Well, 75 then. Okay.
You can, yes, when we come to put the section.
Okay.
Absolutely, no problem whatsoever. So we want to move on now to Section 75, and there's an amendment there in the name of the Minister. I note that acceptance of this amendment involves the deletion of Section 75 of the bill. It's a new section. It's already discussed with 157, and the question is that the new section be there in south. Is that agreed? Agreed. Section Amendment 159 is out of order. It's outside the scope of the bill. I note that this section has been opposed, but again, a new section has been included. So, Deputy McLaughlin, can we note it?
Little earlier,
It's the same thing. You want to speak to the Section 75, Deputy McNamara?
It was
Now,
just-
it's a new section that's been inserted, so we're talking about the new section that's been inserted, which we've already discussed.
Yeah.
So-
Well, what I'm proposing is an additional amendment. I mean, obviously, for any amendment to be raised at report stage, it has to be raised at committee stage. So I think,
Kate, do you want to do it, yeah?
yeah, I think this is the most appropriate.
Okay.
I mean, I'm not certain that I want to do it, but I suppose I'm just seeking clarification. The Minister in his presentation outlined the development of the legal professions in Ireland and the pace of change since 1870. I mean, it's probably not quite accurate to say there's been no change since 1870, although any changes that have occurred have been glacial in their speed. But one of the very few changes that occurred was there was an insertion into the Code of Conduct for barristers to the effect that no professional code shall operate to prevent a practising barrister from sharing any facility premises or costs of practice, including capital or operating costs. Now that is, I suppose, to facilitate quasi-chambers, perhaps, or at least barristers grouping together, sharing resources, as is perhaps most economical, and therefore the economies of scale can be passed on, you would hope, to consumers. So it's a broad benefit of everybody concerned. But I suppose my question is whether this bill envisages, I mean, clearly this bill envisages that you'll have barristers who will remain in the law library, which will probably be the majority, the great majority, but there will be employed barristers, that's clearly provided for, and there'll be barristers in the full-time, in the service of the state. But I suppose I'm not entirely clear, although I think I am, but it would be good to get clarification on whether the Minister envisages that after this, if this bill is enacted, that there will be barristers who are in independent practice, so they're not working for the state, or they're not in employment, or they may be in employment as waiters or whatever, as many young barristers are, but that they're not employed to provide legal services, but who are independent barristers and therefore would receive instructions from solicitors, or indeed from members of the public in non-contentious issues, which is a provision of the bill, but that who may operate in chambers. And it's important, I think, to point out that chambers are not partnerships. The chambers are a collective of sole practitioners. So will there be sole practitioners and/or sole practitioners operating in chambers who are not members of the law library, or do you think that all, is it envisaged by the bill that all independent barristers will have to remain members of the law library? And if the case is that it is envisaged that there will be a variety of of methods by which people can practice, or people can choose themselves whether to be members of the law library or not, well then would an amendment be useful, or should an amendment be considered to the effect that no professional code shall operate to prevent a practising barrister from sharing any facility, premises or cost of practice, including any capital operating cost, or to require a practising barrister to share any facility, premises or cost of practice, including capital operating costs, with one or more other practising barristers?
Very, very happy to answer that. Well, firstly, it's the intention of the bill that a barrister can do exactly what the Deputy is proposing, that there will be no obligation to be a member of the library as such, and that they can ply their trade as a barrister. They can operate an office alone or with others as a barrister, that they will adhere to the professional principles, and that they will be on a roll of barristers maintained by the Legal Services Regulatory Authority. It would be desirable, in fact, if there was only one role being maintained, as opposed to the necessity for two. But we seem to be in a space where there will be a need for two. I'm certainly happy to examine what the legislation in the context of what Deputy McNamara is saying, to ensure that there's no issue or difficulty of any description. But it's certainly the intention and the very specific provisions in the bill dealing with the role of practising barristers to be retained by the Legal Services Regulatory Authority envisages exactly that.
For clarity, and that would include, I mean, obviously there will be practising barristers who are employed by the Attorney General's Office or other departments, will be practising barristers who are employed to provide legal services by banks or other corporations, but that there will be independent practising barristers who are not members of the law library.
Yes.
Oh, thank you.
Okay. Happy with that? Yeah. Thank you.
Yeah.
Okay. Now we'll then put the question about the section. Now again, this is because we've inserted a new section. We're taking out the old one. So the question I have to put is that section 75 stand part of the bill, and that's Anil.
It's Anil.
Anil. The section is lost. Section is lost. Okay. Now we're now moving in, and I know that we're taking a break at 11:15. It is now 11:10, and we have 5 minutes. Will we just introduce this and start it at this stage and give us 5 minutes? We'll break bang on 11:15, no matter where we're at. Is that agreed? Okay. So the next one is section 70, amendment number 160 in the name of the Minister. This is a new section, 160 to 166 inclusive, at a later will be discussed together. Minister to move.
I so move, Chairman. If I can just... Yes, I so move. Government Amendments 160 to 166 form another cluster of amendments which provide a series of regulatory safeguards with regard to how legal services will be protected in MDPs, how consumers will be protected. Government Amendment 160, this relates to partners in multidisciplinary practices. Section 76, subsection 1 provides that each partner in an MDP is jointly and severally liable in respect of his or her acts or omissions, those of the other partners and those of the employees of the partnership. Section 76, subsection 2 provides that a partner of a multidisciplinary practice may share with another partner in the MDP practice fees or income arising from the provision of services by the practice. Section 76(3) is an important section which provides that a person may be a partner in a multidisciplinary practice notwithstanding that they do not provide legal services or services other than legal services. Essentially, this permits a partner in an MDP to provide investment to the practice. Section 76, subsection 4 provides for the prohibition of certain legal practitioners from being a partner in an MDP, for example, where they are subject to an order of the High Court, suspension or striking off. I am giving ongoing consideration to matters such as who can be a partner in an MDP, how best to provide for possible conflicts of interest, the delineation of who can provide legal services or be designated as a managing legal practitioner in an MDP, and I expect to return to these matters further at report stage. Now I want to reference Amendment 161, Managing Legal Practitioner. Many of the provisions contained in Section 77 were previously contained in Section 74 of the bill as published. Section 77 provides that an MDP has to have a managing legal practitioner who is responsible for the management and supervision of the provision of legal services by the practice. The managing legal practitioner is given specific statutory obligations to ensure that the multidisciplinary practice is managed to ensure that the provision of legal services by the practice complies with the Act and the stated professional principles. These obligations relate to the professional independence and integrity of legal practitioners, acting in the best interests of clients, maintaining proper standards of work, compliance with duties owed to the court, and the confidentiality of client affairs. We further developed the role of the managing legal practitioner based on, again, on the New South Wales legislative model. Section 77 will also now provide that an MDP must inform the authority where it does not have a managing legal practitioner in place for 7 days or longer. The MDP cannot provide legal services until a managing legal practitioner is in place. Under Section 77, subsection 4, the managing legal practitioner will be required, where he or she has reason to believe there is non-compliance, to take necessary steps to ensure compliance and to remedy any defaults. I'd like to point out that the Legal Service Regulatory Authority will not be regulating the activities of participants in an MDP who are providing services other than legal services. Where accountants, architects or other providers operate in an MDP, they will be subject to their own regulatory or professional supervisory bodies. Lawyers in these entities will, of course, also be governed by the enhanced conduct, disciplinary and legal cost provisions of the bill. Now, reference Amendment 162. Section 78 provides that nothing in this part prevents an act or omission by a legal practitioner who is a partner in or an employee of a multidisciplinary practice that is in contravention of this part from being found to amount to misconduct under Section 45. Amendment number 163 deals with the operation of a multidisciplinary practice. Section 79 requires the MDP to have written procedures binding on all partners and employees within the practice to ensure compliance with the requirements of the Act and adherence to the professional principles set out in Section 9, subsection 5 of the Bill. This includes an obligation on all to comply with the directions of the managing legal practitioner, any procedures that are set out in regulations governing the operation and management of the MDP. To come back to the conversation that I had with Deputy McLaughlin at the start of this, these are the crucial and important provisions to ensure proper regulatory oversight, and that the sort of concerns that could be raised and that Deputy McLaughlin raised with regard to MDPs are properly and fully and appropriately addressed, and that they're comprehensively addressed.
Minister, can I maybe call a halt there, and we'll break for 15 minutes, and you can
continue
when you come in at that stage.
Very well, Chairman. Thank you.
I would ask everyone to be back on the button at 11:30. Okay, I'll be starting regardless.
Okay.
Okay, thank you. Meeting suspended. resumed in public session. Minister, to resume from where he left off.
Thank you very much, Chairman. Sorry for delaying everyone. Now, I was now moving on to the prohibition on inducement, which is section 79, subsection 3 in the amendments that we're discussing. Section 79, subsection 3 has a requirement prohibiting anyone from inducing or causing a lawyer in an MDP from acting in a non-compliant manner. Then section 79, subsection 4 deals with the requirement that accounting, receipts and fees records for legal services and other services be kept separate. And then we have the non-disclosure provision in section 79, subsection 5, which has a non-disclosure provision where a lawyer cannot disclose the affairs of a client to another person MDP without the express consent of the client concerned. Just want to say something about that. I think I'm right in attributing this to at least one of the submissions from the Law Society, where they logically pointed out that if you were running an MDP as a one-stop shop, clearly the person who was the lawyer dealing with, if you're going to have a one-stop shop operating, would need to be able to communicate with other professionals in the MDP with regard to the issue under discussion. The intent of the section as drafted is clearly where if you go, you may go into an MDP and you may only want the services of the lawyer. You may not want the services of the other professionals, and you will want to be able to consult that lawyer, and you may not want your business discussed with other professionals. On the other hand, if you're using what I describe the one-stop shop, and you expect your lawyer and your accountant and the MDP to talk together, there will be a simple signing of the written consent, and those conversations would take place. So it does allow a lawyer operating with an MDP to, what I describe as provide traditional legal services. Other professionals that they're working with wouldn't have access to confidential information. But where you're using it as the one-stop shop because you're dealing with a number of professionals, that would be explained. You'd sign a consent and there would be no question of information being dealt with within the firm in a manner that the client was unhappy with. Now, we'll have a further look at the way this is framed, but in the context of concerns that people have expressed about MDPs and how they might operate, in a sense, we're being quite conservative in the manner in which we're dealing with matters to ensure all of the multiple protections are in place and the people are fully informed in the context of their consulting with the practice, and that there's, I suppose, a formal consent to the sharing of information with regard to an individual's circumstances within the practice between a legal professional and others operating in other areas to which the practice is in which the practice is engaged. But as I say, we're working through this, but that's the intent of the amendment as prescribed. I then move on to the issue of inspection. The entitlement of a person to inspect an MDP or obtain information from a partner or employee in an MDP regarding the provision of services other than legal services under an enactment or rule of law is upheld under section 79, subsection 6. For example, a regulator professional body, public body may have a right to inspect the premises in which a particular person or member of a particular profession carries out their business. The Legal Service Regulatory Authority will have its own separate powers of inspection under the bill, to which I will be returning a report stage. I now want to return to Government Amendments 164, 165, 166. They deal with the letter of engagement, professional indemnity insurance, and the saver for the compensation fund. Section 80 is based on a provision, again in the legislation on MDPs in New South Wales. Can I just say, Chairman, in referencing particularly the New South Wales legislation, the huge benefit of this is that MDPs have been there for some years. They've teased through initial teething issues, and they've addressed matters by way of legislation in a manner that's practical to ensure that they can fully and properly work, and also there's appropriate oversight. So there's a very, very useful touchstone of expertise with regard to the workings of MDPs. Indeed, when I visited Australia some time ago, I had very detailed conversations in that regard with the relevant authorities there. Section 80 provides for client protection at the point of engagement. by the provision of a letter of engagement which specifies what services are being provided, including which of those services are legal services being provided by a legal practitioner, which services are non-legal. And again, I'm conscious that there currently law firms, in the manner in which matters are dealt with, may provide services that could be regarded as legal services or that could be regarded as financial services, and that there may be a grey area in that context. But if you have a detailed letter of engagement detailing services, it's quite clear what are regarded as the legal services within the MDP and what are regarded as the non-legal services. The letter of engagement also has to specify which of the services are to be covered by the compensation fund. Now, I know, again, that was a Law Society concern, which is that there might be a myriad of inappropriate claims made against the compensation fund in circumstances in which it might be alleged that something was a legal service and in circumstances in which it isn't. Now, I think all of these matters can be adequately and properly dealt with through the regulatory structure, but there's the Legal Service Regulatory Authority itself, in the context of regulations it will inevitably make following the consultation process, may address these issues further. But the letter of engagement, if I could say it, was just an indicator of our awareness of this issue and of the need at the very start-up point of dealing with a client of there being clarity. An agreement as between a client and the solicitors, for example, or the agreement between the client and the MDP as a firm, as to what services are legal services, what services are to be otherwise designated. Section 81 provides that professional indemnity insurance must be held by an MDP to cover all of its services. In a saving provision, Section 82 provides that nothing in this part of the bill shall be construed as extending the obligations of the Law Society in relation to dishonesty arising in an MDP on the part of a legal practitioner who is not a practising solicitor. Now, in concluding, Chairman, my introduction to the proposed amendments to Part 7 of the bill, I'm happy to acknowledge that the ongoing views and concerns that have been conveyed to me by the Law Society and others in relation to these provisions, these and other aspects of the bill in relation to which views have been received will be taken into consideration as part of the process for the bill's forthcoming report stage. However, the provision being made in this part of the bill for the regulatory introduction of legal partnerships and multidisciplinary practices remain fundamental to the bill's delivery of alternative legal business structures in support of greater competition in the provision of legal services in the state, the benefit of legal practitioners and the consumers of their services alike. And those who have made submissions suggesting that we should remove from the bill the provisions with regard to legal partnerships, as for example between barristers and barristers, or with regard to MDPs. If we were to do that, we would be fundamentally changing the bill in the area of seeking to ensure a multiplicity of optional business structures to which legal services can be provided.
Okay. Deputy McLaughlin, you've indicated.
Yeah, you've acknowledged the submission from the Law Society. I'll get into that in a second, and some of their recommendations, just to get your thoughts on them. The first point I want to raise, though, is in relation to you'll come to this later on in the amendment, but in relation to the role of practising barristers. Well, in terms of the existing section has been changed, is proposed to be changed to what the minister is putting forward. Yeah, maybe visit it. I'm just trying to see here. Yeah, maybe take it in amendments 172. Yeah, maybe.
So we're on 160 now to 166, just to be helpful there, if I can.
Yeah, I'm just trying to.
They're all new sections that are being proposed.
Okay. I just want to clarify something, though, Chairman.
Okay.
See, in terms of Amendment 172, yeah, section 76, yeah, that's okay. I'll deal with that issue then. Yeah, that's fine. Okay, well, to get into the Law Society concerns, okay. This is in terms of the amendments that he's just read, 160 to 166.
Thank you.
I'll just deal with them now, okay? Minister, the Law Society submission talks about that they have concerns around the managing legal practitioner will be responsible for the management and supervision of the provision of legal services by the MDP. There are no safeguards in place to ensure, and they're just also concerned about the scope of the definition, as well as the complete absence of controls with regard to who can provide legal services within the NDP. So I'll just maybe move on to the recommendations, right? So,
161 now you're on at the moment.
160 to 166. This is in relation to the amendments that the Minister.
I know, but the actual one you just mentioned was managing legal practitioner, which is Amendment 161. That covers all that.
Yeah,
it's
the new section 76. And in fairness, this submission follows the fact that you give us the amendments early, so it's actually very helpful that we can get submissions on your amendments. And that's I have to thank you for giving us the amendments ahead of time on this occasion.
Helpful.
Well, it makes our job easier. So it's in relation to these.
I enjoy giving you a greater opportunity to beat me up, you see.
Well, no.
It's part of the
let's get back to
it's part of my personal masochistic tendencies.
In fairness to the Chair, the Minister did acknowledge the submission and the concerns. In fairness, he did. So what was, I'll just say a few of the points here. It's a recommendation of the Society that a requirement should be introduced for non-legal practitioner partners to be members of regulated professions such as accountants, actuaries, architects, etc. This would fit the ethos of what an MDP is supposed to be, namely a multidisciplinary practice rather than a vehicle for unqualified persons to provide legal services. That's the first recommendation. The next one is, this is in relation to this new section 76. It is a recommendation of the Society that bodies corporate be prohibited from acting as non-legal practitioner partners in MDPs. Next one then is, it is the recommendation of the Society that the provisions of section 76(4) of the Minister's proposed amendments be extended to cover all legal practitioners restricted, suspended or struck off before the commencement of the Act. That's an important point, before. And then moving on to section 77, as you suggested it is the recommendation of the Society that the regulations and requirements of NDPs with regard to client monies and client accounts be no less rigorous than those in place on solicitor firms. Letter of engagement. The recommendation there is that this is in relation to the new section 80, letter of engagement. They're saying there that, again, it is the recommendation of the Society that clearer definitions of legal services and non-legal services with regard to MDPs are put in place. They continue, it should be noted that in both section 80 and section 82, the relevant sections in the Solicitors Acts in relation to compensation for loss due to dishonesty of a solicitor should be section 21 of the Solicitors Amendment Act 1960, as substituted by section 29 of the Solicitors Amendment Act 1984, as amended by section 16 of the Solicitors Amendment Act 2002. So just to get your feedback on those issues, Minister.
Yeah, well, I'm looking at exactly the same document, Deputy, which I received a few days ago and personally went through, as I know my officials did. I referenced it earlier as a constructive and helpful document in the continuing development of the bill. Indeed, I think earlier I would have addressed some of the issues the Deputy has just mentioned in passing. I don't want to delay the committee by going into each of these, but suffice it to say that I think it's a very helpful and constructive submission, and we are carefully looking at it. There are some issues, I think, that give rise to concern where there isn't a need for concern. I think there's some additional tidying up we can do on the bill, and I very much welcome the fact that we received the submission, and I can say to you that we would be constructively engaged with it to the extent of ensuring that the objectives of the legislation are fully achieved, and that we have what is the right and appropriate regulatory structure in place in this area, with no room for ambiguity or concerns, and I've no doubt that we'll be returning to these issues, Chairman, at report stage.
Thank you. Okay, all finished?
No, Chairman, I could do what the Deputy has invited me to do, because it's my own extensive notes on this document, but I delayed the meeting for about the next hour as we went through each of them. But it's a useful exercise. I appreciate the Deputy putting these matters on the record, and we'll come back to it at report stage.
I just want to say for the record that it is really important for us, particularly in large complex bills which we don't have a range of expertise in, that we get amendments in advance, as we have on this occasion, and then it helps the stakeholders to advise us and advise the Minister. And in fairness, this is a submission to the Minister that we're being made aware of. So I think it's actually very good for the process of making a bill stronger. So just to put that on the record. Okay.
Thank you. Deputy Collins, you want to come in on something?
Just through the Chair. Minister, can you just give us where you're minded in relation to the provision of the non-legal services? Are you open to restricting, it's in the submission, the range of non-legal services which may or may not be provided in the future under the multidiscipline practices?
Yeah, that's their amendment 2.29 on the page. Yeah, it's an interesting issue, which I was reflecting on following receiving this. It seems on the surface an attractive issue, but it may not entirely be. If I could talk about, for example, my own area of legal practice over the years, to which I don't anticipate I'll be returning, so I've no particular vested interest in the outcome of this in the context of the legislation. Say you take a family law practice. I could well see a solicitor's firm practicing in family law, interested in dispute resolution, dealing with people with very difficult parentage disputes over children with regard to custody and access issues or relationship issues, deciding that wouldn't it be a good idea that someone created a family law practice in which you had two well-qualified family counsellors, a family mediator who might help mediate disputes, they didn't have to go to court, and a number of possible lawyers, and they might equally decide that they bring in some pension expert to provide advice on that. I don't know, I'm just speculating and how it might go. Now, in the context of people dealing with family counselling, I'm not sure that there is an overall professional organisation that provides a disciplinary oversight of family counsellors. I think one of the issues is an individual properly qualified and experienced, but that there isn't, as you would have in the accountancy profession. So I've some concerns about the idea that you restrict it in the manner that's suggested. I can see the attractiveness of it in the context of disciplinary matters, but I want to be very careful as we think this through that we don't create other difficulties. In the mediation area, both deputies, chairman, all members may be familiar with the heads of the bill, with the mediation bill that we published, and there's further work being done on that. And there isn't an overall body, an overall national body, for example, presently that is engaged in regulatory oversight of mediators. There's different groups of mediation type groupings, commercial groupings, groups who teach people mediation from different walks of life. I would have thought, for example, if you take a commercial practice, a lawyer's practice, a multidisciplinary practice, you have quite a number of lawyers who've become either arbitrators or mediators. But you have some non-lawyers that become arbitrators and mediators. And indeed, the Bar has an organisation of joint barristers and arbitrators to provide alternative dispute resolution stuff. In the absence of some overarching regulatory body for mediators, would you exclude a mediator from being part of a multidisciplinary practice? So I think it's perhaps more complex than the Law Society perceived it. I can well understand why they made that proposal in a regulatory framework context dealing. In some areas, it is important that you have that oversight. So in conclusion, Deputy, we're reflecting on this. What I don't want to do is exclude, whether it's the family law area, the commercial law area, the possibility of an engagement by other professionals whose skills are complementary to the service provided and who could provide those skills to the benefit of the general public within an overall one-stop shop framework. And it seems to me there are well-qualified, well-trained individuals working currently in the community who could be excluded from being part of a multidisciplinary practice on the basis of what the Law Society is proposing.
Thank you, Minister. In fact, we did some work on the mediation bill, Heads bill, way back last year sometime. Okay, so I think if we're all done on that, we'll start working through these amendments there. Amendment 160 in the name of the Minister. The question is that a new section be there instead. Was that agreed?
Agreed.
Agreed. Amendment 161 in the name of the Minister. Minister to move.
I move.
The question is that the new section be there instead. Is that agreed?
Agreed.
Agreed. Amendment 162 already discussed. 160. The Minister to move.
I move.
The question is that the new section be there instead. Is that agreed?
Agreed.
Agreed.
Agreed. Amendment 163 in the name of the Minister. Already discussed with 160 new section again. Minister to move.
I move.
The question is the new section be there instead. Is that agreed?
Agreed.
Agreed. Amendment 164 in the name of the Minister. It's a new section. Already discussed with 60. Minister to move.
I move.
The question is the new section be there instead. Is that agreed?
Agreed.
Agreed. Amendment 165 in the name of the Minister. Another new section. Already discussed with 160. Minister to move.
I move.
And the question is the new section be there instead. Is that agreed?
Agreed.
Amendment 166 in the name of the Minister. It's a new section. Already discussed with 160. Minister to move.
I move.
The question is the new section be there instead. Is that agreed?
Agreed.
Agreed. Amendment number 167 in the name of the Minister. Another new section. Already discussed with 157. Minister to move.
I move.
The question is the new section be there instead. Is that agreed?
Agreed.
Amendment 168, again in the name of the Minister, it's a new section. I discussed 157. Minister to move.
I
The
move.
question is the new section beyond itself. Is that agreed? Amendment number 169, in the name of the Minister, it's a new section. I discussed 157. Minister to move.
I move.
The question is the new section beyond itself. Is that agreed?
Agreed.
Amendment 117, in the name of the Minister, it's a new section. I discussed 153. Minister to move.
I move.
The question is the new section beyond itself. Is that agreed?
Agreed.
Amendment number 171 is a new section. I discussed 153. Minister to move.
I move.
Question is the new section beyond itself. Is that agreed?
Agreed.
Amendment number 172 in the name of the Minister. Acceptance of this amendment involves the deletion of section 76 of the bill. This is a new section. Amendments number 172 to 176 inclusive are related and will be discussed together. Minister to move and discuss.
I so move, Chairman. Part 8 of the bill now makes the Legal Service Regulatory Authority and not the Bar Council responsible for the keeping of the role of practising barristers. This is a policy decision based on the fact that the Bar Council does not wish to be held responsible for maintaining a role or collecting a levy payment from barristers who do not come under its aegis as members of the Law Library. This bill will comprehend suitably qualified persons who have been duly called to the bar and who practice as barristers outside the traditional practice model of membership of the Law Library. Non-law library members, such as in-house counsel, partners in a legal firm, or a multidisciplinary practice, and other sole practitioners, will therefore come under the role of practising barristers. I'd wish to recall, as previously indicated, that I will be returning at report stage to the interpretation provisions in Section 2 of the Bill, as it relates to important terms such as those of practising barrister and legal services, in order to reflect the Bill's development, including during this current committee stage consideration process. I'd now like to take the committee as briefly as possible through the part as presented to the committee today. Section 76, inserted by Amendment 172, provides that the new Legal Service Regulatory Authority will set up and maintain publicly accessible role of practising barristers. Every suitably qualified person who intends to so practice will be required to apply to the authority to have their name entered on the roll in accordance with Section 77. Section 78, based on Section 79 in the published bill, deals with the variation of entries on the roll. The section provides for the removal of a person's name from the roll for a variety of serious disciplinary-related breaches or where requested by the person or upon the death of the person. The section is essentially pro forma. It has only been amended to reflect the fact that the authority and not the Bar Council will be in charge of the roll. I'll also have to make a small correction to this section, a report stage to remove the reference to section 38 subsection 10, which was deleted at last month's committee sitting and so should be referenced no longer. New sections 79 and 80 provide that unqualified persons and persons whose names are not properly on the roll of practising barristers will face sanction if they attempt or pretend to practice as barristers. This ensures that equivalent provisions to those already in place for solicitors under the Solicitors' Acts are also in place in relation to barristers.
Deputy McLaughlin, you've indicated it?
Yeah, there's a little bit of a conundrum here in this one, Minister, that's the role of practising barristers now being taken under the aegis of the new regulatory authority is a difficulty in that the bill acknowledges the existence of the Law Library and the Bar Council. Therefore, the logic must follow that the Bar Council should continue to be entitled to assist that its members operate within the confines of a code of conduct that prohibits practice with a legal partnership, employment or MDP structure. How do you deal with that conundrum?
Very simply, this brings us back, Deputy, to nolumus mutare, which properly translated means we will not be changed. That is the special plea from the bar saying, do nothing, change nothing, don't allow members of the barrister's profession to operate as partners, don't allow them to open chambers, don't allow them to share fees, don't allow for any change of any description, because this is our motto, nolumus mutare. It's a special plea from the bar to have removed the provisions already in the bill that seek to stop the continuation of the restrictive practices which are currently incorporated within the bar's code of practice.
With respect, though, Minister, how can the Bar Council, which is acknowledged that it exists, and the Law Library exists, it's acknowledged by this bill, how can they, what do they do? Do they have to, they have a code of practice, bars, how do you deal with that conundrum? So just deal with that first and I'll come back.
Well, I presume they will exist. There was in my early college years, when I didn't know what it was I wanted to do, I studied philosophy, and I always found Descartes extremely interesting. And one of the great Descartesian principles in wondering about what the world was really about was to say, I think, therefore I am. I think the Bar Council, it exists, therefore it will be, except, and it will have its code, which will have to be in compliance with the legislation enacted by the House of the Oireachtas to the extent that there's any oversight of ensuring that restrictive practices aren't enforced. Currently, there's restrictive practices. The restrictive practices prevent members of the bar forming partnerships with other members of the bar. Restrictive practices prevent members of the bar forming partnerships with solicitors. Restrictive practices prevent a person who is a barrister remaining a barrister if they're employed in a solicitor's firm. We have the bizarre situation recently where a well-known English solicitor's firm decided to set up offices in Ireland, and they wanted to employ solicitors. They wanted to employ individuals with particular legal expertise, and I understand that they employed more than one barrister. And the barrister wanted to continue to do what the barrister had always done, which is provide expert legal service and be entitled to appear in court. But if the barrister had remained a barrister, because they were employed by a solicitor's firm, they presumably might have been struck off by the bar. So the barrister did a very simple thing, chameleon-like, because the rules now provide for it, was able to, within a short few weeks, transmogrify from being a barrister into becoming a solicitor. And ergo, the barrister who was a barrister is now a solicitor and can continue to do exactly what the barrister did, which is give legal advice and appear in the courts. Now, if people... This legislation, based on the perspective of providing additional competition, based on removing barriers from competition, having regard to providing alternative means to deliver legal services as well as receive them, makes it clear that that aspect of the bar's code of practice will no longer be legal in this state. Simple as that. But the bar will continue to exist and flourish, I've no doubt, and I wish everyone well in that context, because members of the bar perform an extremely important role in providing legal services. And despite some perception to the contrary, I've got the greatest of respect for lawyers in both professions who have great expertise, who do very interesting and challenging work, and who are very important role in protecting the rights of individuals. But protecting the rights of individuals has nothing to do with maintaining restrictive practices that have developed in the 1800s. We live in a different world. So I think it's unfortunate that there's a need to maintain two roles. I think it would have been helpful if there could have been a single role of barristers, whether they're formerly members of the law library or not, and that literally barristers are barristers and you have a single role, and some can choose to be member of the law library, and those who aren't members of the law library will practice as they deem appropriate in the manner in which Deputy McNamara mentioned, and I think it would be preferable that there be a single role. But I'm advised that the bar isn't agreeable to maintaining a role which includes members of the barrister's profession who aren't members of the law library. I personally think that's regrettable, because I think whether you're a member of the law library or whether you're not, if you're a practicing barrister who has graduated through the process of becoming a barrister, who's passed their exams, who've gone through all of the training, I don't see any particular reason why we should need to maintain two separate roles, but apparently we do. As someone who is a member of the solicitor's profession, solicitors since 1971 have been able to do all of the advocacy work throughout the court system as well as general solicitors' work. Now, over the years, I was one of the very few solicitors who dealt on a regular basis as an advocate in the higher courts. The Law Society didn't, and there are a lot of solicitors who don't want to engage that way, and I fully appreciate and understand this. There's many who act as advocates in the district court, but not in the other courts. It's a matter of choice. The Law Society didn't feel the need to maintain some exclusive role of solicitors who are advocates in the higher courts. I don't understand why the membership or not of a library should require that you're excluded from a particular role when you're a practicing, qualified barrister who's gone through the King's Inns and acquired all of the relevant qualifications that entitle you to be recognised as a barrister. But unfortunately, it appears to be the case that we have to maintain two roles.
So just to wrap up, then, so to be very clear, the Bar Council's code of practice would be unenforceable in this regard as a result of this legislation?
So far as it provides a restrictive practice that the legislation makes clear is no longer legally allowed.
And then the final point I want to make is this. You see, if you or I were to do a vox pop in any part of the state and ask somebody in any big city or town or country town land, what is their big issue with barristers? They would say costs. They would say, they look at now, let's be clear, not all barristers are fortunate enough to benefit from government contracts or private sector. But when you look at the cost of High Court, a day in the High Court, the prohibitive cost of some people to get access to justice or to defend themselves against the state, that is the issue, massive costs. There's nothing in this bill that deals with that. So what this bill, so that is the overwhelming public interest. It was how to get the cost of pursuing justice to reduce it down significantly. But what we have here is your own passion, and that's fair enough. You're entitled to it, and you're a learned man, and you have strong views about these matters. Okay, through the chairman. Well, me and the minister enjoy these talks, but I was going to get a candle and a bottle of wine there, but.
Amendment 172 to 176, you know.
You're a bit of a gooseberry here, Chairman, you know. Love trust, you know.
Just, if Deputy McLaughlin's going to get the can and the bottle of wine, could I put in a claim for gin and tonic and a pack of peanuts?
Back to Amendment 172 to 176. Deputy McNamara, you want to come in there, please?
Yeah, but maybe if Deputy Collins, okay, it's 170, or sorry, the proposed it's Amendment 172, the proposed Section 76. Firstly, I'd like to say that I welcome it, and the fact that a unitary role will be maintained, because I had misunderstood or was under the misapprehension from what the Minister said at the last committee stage meeting that the Bar Council will continue to maintain the role of practising barristers who are members of the Law Library, and then a separate role will be maintained for those and only those who aren't. So it's good that there seems to be a unified role. Well, that's what it says anyway.
Sorry. Yes, sorry.
Yes,
It's one role for both that's being maintained by the...
Yes,
sorry,
that's-
yes.
I greatly welcome it.
I got one thing wrong when I suggested we're going to maintain two roles. It's one role for both being maintained by the regulatory authority rather than one role being maintained by the bar. I beg your pardon. So I was inaccurate because I was thinking back to a further, an earlier issue that we had. That is the reason why. That is the reason why it is the regulatory authority, not the bar, maintaining the role. So I want to just apologise, Chairman, if I gave... I was misinformed in one comment made about maintaining two roles. It goes back to a conversation where if we hadn't have brought the whole thing into the regulatory authority, there would have been two roles, and this was the solution. This was the solution to it. But the other side of that is that this Law Society are continuing to maintain the role of solicitors, and I would have preferred and would have thought it wasn't necessary that the Legal Service Regulatory Authority do this, that it was that the bar could have maintained the role, but in circumstances where we'd have had two roles, we brought the whole thing into the Legal Service Regulatory Authority. That's...
But I welcome that. But notwithstanding that, I would have several questions. I mean, it would appear to me that the purpose of the role will be a public document. Clearly, it can be inspected, or it's envisaged that it could be publicly available on a website, and certain details will be available in respect of all barristers, all of which is entirely sensible. Those details, you know, will be furthering the objectives specified in 9.4, which includes, you know, informing the public of available legal services and also maintaining competition. But, and I would have no objection to any of the information which it is provided will be specified in respect of barristers, but I just wonder whether some additional information might also be useful. Obviously, it's useful to know whether a barrister is a member of the Law Library or not. It's useful to know whether they're in full-time service of the state or not. But I just fear that a consumer looking at that might think that only barristers who are in the full-time service of the state might be available. Only barristers who are not in the full-time service of the state, all barristers who are not in the full-time service of the state might be available to act against the state. I mean, an issue which I raised at second stage is the fact that the Minister's Department requires undertakings, particularly in the area of immigration and asylum, not to act against the Minister in those areas. Now, it's a policy which I disagree with. I think it offends the principle of an independent bar, but nevertheless the Bar Council have acquiesced, if not agreed, with that policy over a long number of years. And there's also then the issue of, we know that there will be barristers who will be employed to provide legal services by banks, companies, etc. I mean, it's not reasonable to think that those barristers would be available to act against their employer. So if somebody is employed, not employed, as I say, selling, well, as a waiter or in any capacity on a part-time basis, but is there specifically employed to provide legal services, it might be useful if that is registered on the register. If a barrister, whether or not they're members of the Law Library, and there are many members of the Law Library who are precluded from acting against the Minister's Department, I think it would be useful if that information is specified on the register. Because it's information which I think is vital to consumers as they seek to obtain a barrister. Also, you know, some barristers will be available to be instructed by persons who are not solicitors. Obviously, it's limited to non-contentious issues for the moment. But not all barristers will want to be approached by non-solicitors. And that, I think, would be useful for the public to have that specified. And also then to specify, because there might be a misapprehension that only barristers who are members of the Law Library are independent barristers who will take instructions from solicitors in villages and towns up and down the length and breadth of this country. And it might be useful to specify whether barristers are available to be instructed in contentious matters. Now, I don't say contentious matters by solicitors because I'm aware that I wouldn't want to preempt any public consultation which is envisaged in our Amendment 171, but that whether they are available to be instructed in contentious matters or not, because there will be particularly employed barristers and barristers who are in the service of the state who won't want to be engaged or instructed in contentious matters. So if the Minister, it might be useful to consider these amendments, and I raise them now because they have to be raised now to be raised at a report stage. So that's one issue. There's a number of other issues. Maybe it's better to...
Submit those yourself anyway.
Yeah, I can do, but there's a number of other issues which I wish to
Minister wants to
respond
respond.
to those.
Firstly, I very much value Deputy McNamara's insights and experiences we've been going through the bill. It's most helpful. And he's raising an important issue. It's one that we gave some thought to, and it's interesting arising out of our deliberations that there is an issue about whether we bring forward some additional provisions, some amendments to this particular provision at report stage, having teased it out further, which we wanted to do. You'll see in section 76, the subsection 5 that we have, it says that the authority may, having regard to the objectives specified in section 9, subsection 4, prescribe additional information in relation to professional qualifications and areas of expertise the practising barrister concerned that is to be contained in an entry on the roll. Now, that, of course, would give the authority some discretion to determine what additional information might be included. I could see advantages in providing at report stage for the express inclusion of some of the matters the Deputy has raised, and indeed arising out of his contribution, I would have a particular concern that we may need also to consider in this context. If you take subsection 4, 4b, of course, relates to subsection 5, but the specification whether someone's a member of the Law Library, whether he or she is a full-time service of the state. In circumstances of barristers who are not full-time members of the Law Library, and in circumstances where members of the public may not understand the nuances of whether you're a member of the Law Library or not, on reflection I would have some concern that a member of the public who, for example, wanted to approach a barrister directly on a non-contentious matter might have a less favourable view of a barrister because they're not a member of the Law Library than if they were. They may think that it's some black mark against them because here you have so many who are ticked off as members of the Law Library and so many who aren't. It's important, I think, that that information is available, but it's important that the manner in which it's made available doesn't result in the wrong conclusions being drawn about the expertise of others and their capacity to undertake particular legal work. So I want to thank particularly Deputy McNamara for raising this particular issue, because the reason for putting in subsection 5 was that I was troubled with regard to whether everything that needed to be incorporated on the roll had been designated, and I thought it was important that the Legal Service Regulatory Authority reflect on that, and that reflection would also be relevant to the consultative process they have to engage in. But I think we'll have another look at that section for report stage, and indeed if members of the committee chairman have a particular amendment that they would like to suggest to us as we lead up to report stage, as opposed to it becoming necessarily an issue just arising on the day, I would very much welcome that.
By the way, there's a phone on somewhere. I hear interference. Could everybody check, please, and put the phones either off or away from the mics? Would everybody just check your phone now, please? Physically check your phone.
Mode, so it
Doesn't matter. It has to be
off. Okay, I'll turn it off.
It has to be completely off. Thank you. Or else put it away behind, out of the way, so it won't interfere with the mics. Thanks very much.
If I can just raise a couple of other issues. Subsection 6 provides for a separate commencement date. I mean, why? I would have thought that logically, and that this section would be commenced with the establishment of the authority. So why is there a separate commencement date envisaged? It's just a question that I would have, Chairman. Then the Minister, when opening this section, or Part 8, or introducing the amendments at Part 8, mentioned a levy, and I'm presuming that there will be some cost in being entered upon the roll of barristers. And I suppose the question I would have would be, will that cost be the same for all barristers, regardless of whether they're sole practitioners in the law library, out of the law library, in the employ of the state, not in the employ of the state, etc. Would the Minister, and it's something that I raised at second stage, would the Minister consider something similar to Section 51 of the Legal Services, the UK Legal Services Bill 2007, which provides that fees can be applied to certain permitted purposes and only to those permitted purposes, and they're set out. As I explained at second stage, my concern would be that we'll have a number of barristers, that the great majority, I expect, practicing in the law library, and then we'll have others in various configurations outside of the law library. But in order to become a barrister, all of them will have had to have done a pupillage, or have devilled for somebody, as it's called, just as all solicitors will have had to have served an apprenticeship. But the reality is that people won't, I expect, to be doing pupillages in the Minister's office or in the Attorney General's office or in banks or in-house. They may, if chambers are established, they may end up doing pupillages in chambers, but the great majority, and in fairness to the Bar Council and the Law Library, they have made great efforts to ensure that everybody who comes down from King's Inns can do a pupillage, and that maintains a wide access to the profession, which is a very important aspect of competition. But I think it would be slightly unfair if the cost of pupillages and maintaining pupils, giving pupils, I'm not saying paying them because they're not paid, but nevertheless they do incur a cost of living, and it would be very detrimental if only those whose parents can afford to support them can do pupillages. And it would similarly be quite unfair if the law library were to bear, or members of the law library were to bear all the cost of pupillages, which are essential to accessing the profession. And then those who benefited from that system would then go in-house. I mean, maybe there's room for a levy to be imposed on all practicing barristers that could then be used to pay pupils. It's just a proposition. I don't know, but I would be concerned that I agree entirely with the Minister's proposals with regard to opening up the bar, but I would be afraid of an unintended consequence that it might be that the configurations with which you could practice would be far wider, but getting into becoming a barrister could be narrowed because, you know, without wishing to repeat myself, the law library and those members of the law library are the only ones who bear the cost of pupils. There are two other issues which I wish to raise. The Minister also mentioned in passing the anomaly regarding the English firm which wished to establish, or the UK firm which wished to establish itself here and had a barrister who they wished to employ. But is that not maintained, or perhaps I'm misreading section 116, subsection 4, where it says, in this section, employment includes part-time employment, but does not include employment by a solicitor. So does that preclude, does that maintain the anomaly which the Minister described? And it's just a question that I require clarification on, Chair. And then I suppose finally, there's the only issue which I wish to raise at this stage is the issue of a representative body. Obviously, the Bar Council have declined for, as they're perfectly entitled to decline, to register non-members of the Law Library. Well, actually, they're not, perhaps, it's not as straightforward as perfect, because their rules, their constitution requires that they would register non-members of the Law Library, but they don't. But their constitution also says that they represent the Bar of Ireland and all of the Bar of Ireland. The Bar of England and Wales represents all of the Bar of England and Wales, whether people are in sole practitioners, which are relatively few, whether they're in chambers, whether they're in the Crown Prosecution Service, employed or otherwise. It is, I think, useful to have a representative body which represents the whole profession. Obviously, the Bar Council and freedom of association requires that the Bar Council can accept whatever members they wish and dissociate themselves from wherever they wish to dissociate themselves from. But I mean, I'd be sort of slightly sceptical about having, to quote from the Life of Brian, you know, the Judean People's Liberation Front and the People's Liberation Front of Judea. You know, it is useful when there's one body that represents all barristers, because the representation of those at the bar is an important aspect of the administration of justice, and I think they are in a unique position to promote certain values, the rule of law, which they consistently maintain, and human rights, etc. But again, I suppose that's perhaps less an issue for the Minister than for the Bar Council themselves.
4 issues there, so Minister, let's come in any of those in the meantime. The commencement date, the costs and fees, the UK barrister moving over here, and the role of the bar representing barristers.
Education and access, and how that will be paid for.
Sure.
Thanks.
Minister.
Yeah, I might take them in reverse order. I think there's a great advantage in having representative bodies like the Law Society representing solicitors, the Bar representing barristers. I think it's a very important role to be played. I think I'm right, but I'm open to correction, that those barristers who aren't presently members of the Law Library, I'm not sure that they are officially represented at the moment by the Bar, but I'm open to correction on that. But yes, I agree with you. We don't need. I think there's no advantage to anyone to have splinter organisations, and rather than.
There is a phone on. It's not yours by any chance. There's a phone on somewhere that's when that mic comes on, it's interfering. Maybe they whatever phone it is. It has to be completely off or else away, because even if they're on silent mode, they still interfere with the systems. Tempted, but I won't. Minister, carry on.
Problem with Deputy Collins Chairman is that he sees bugs everywhere.
I hear them as well.
Apparently he even reads scripts that apparently might have derived from people being bugged, which is very interesting.
Can we get back to section 76, please?
The issues that have arisen. So yeah, I would hope, I'm conscious that we're in a time of change. I'm conscious that organisations have difficulties with change. And I would hope that when we move on from enacting the bill, when the Legal Service Regulatory Authority is in place, when change has been effected, that we will, in 2 years' time or 3 years' time, look at a situation where the Law Society represents all practising solicitors, the Bar represents all practising barristers, be they members of the Law Library or not, and that the disparate elements within each of the professions in the context of their engagements in providing legal services and the manner in which they engage with the public are appropriately feeding into the policy dimensions and approaches taken by the two professional organisations to issues when they arise. I think there's a huge benefit in that because the alternative is you have alternative organisations established and they spend half of their time cannibalising each other rather than focusing outwardly on issues which are genuinely of benefit to society and indeed to their own members. But I can't address those issues. They're internal issues. On the issue of the why a separate commencement date, well, it's envisaged that you clearly that there'll be a 6-month period following on during which the Legal Service Regulatory Authority will have to establish the new role. You can't have a situation where there's an old role that's not applicable and there's a new role to be established and no one's on a role. So it's purely a mechanical administrative issue to be dealt with, Chairman, and obviously, like in everything else, we're open to any suggestions in that context. The levy, it's envisaged that all barristers who are on the roll will contribute to the levy. I'm conscious that, again, the levy has to be set by the Legal Service Regulatory Authority based on the principles prescribed in the bill, which seek to also have regard to the differentiation between the number of solicitors, the number of barristers, the nature of the engagement, perhaps by solicitors with disciplinary issues, and nature of engagement with barristers, and it would obviously be open to the Legal Service Regulatory Authority to take a view with regard to how a levy might be dealt with vis-à-vis young, recently qualified members of the legal profession who may be earning very little by way of income and others. So there's issues there to be dealt with. On the issue of employment of barristers, no, I mean, it's envisaged not that if a barrister is employed in a legal practice, either to do non-contentious work, or if an employee barrister was employed, let's say the legislation is enacted, we've dealt with any regulatory issues, and a barrister is employed by a firm of solicitors as a barrister. There'll be nothing to stop that barrister doing contentious work, but they will only be able to do it because they've been instructed by the solicitor in the firm to do it. There'll be an employee barrister who will be able to appear in court on a regular basis and will represent clients of that firm. Now, it would be open to that firm to decide that on issues that they have no engagement in at all, that barrister might do other work. I don't know, but they would have to be instructed by solicitors where it's contentious work. And there's the regulatory oversight and issues to be addressed by the Legal Service, the Regulatory Authority, during the consultative process. It isn't my understanding or intended in the bill that if a barrister is employed as an employee within a solicitor's firm, that they're only there part-time. But coming back to discussion I had with Deputy McLaughlin earlier, it's also not envisaged that if a young barrister, or they don't have to be young, but if they became an employee in a solicitor's firm, that's what they are for the rest of their days. Like anyone else, if they're employed, they'll be employed presumably on some basis. If they decide they want to go back off to the law library and operate out of the law library, it's assumed that they will do so. It is also incidentally assumed that there will be no code of practice in existence that will prohibit or prevent them from doing that. And we won't see any new restrictive practices introduced that could defeat the purpose of the legislation. But in this day and age, I mean, and the odd thing is solicitors, to some extent, are in a better position than barristers, and solicitors are still instructed by individuals from all around the country, depending on if they have particular areas of expertise. It is quite odd that a solicitor can do all the solicitor's work at the moment and all the barrister's work, and no one suggests that attacks the independence of solicitors or undermines the administration of justice, but there should be a suggestion, as is coming from some quarters, that if a barrister was employed within a solicitor's firm, or as a partner with a solicitor, or as a partner with another barrister, that might undermine the system of injustice and the independence of the legal profession. It frankly makes no sense, but it is an indicator of the extent to which there is discomfort with change. And I genuinely understand in circumstances where there's been so little change within a profession for over 100 years that there is a natural resistance to change and sometimes too much focus on trying to identify all of the reasons why there should be no change in reform rather than actually identifying the benefits of change.
On education and maintaining pupilages and maintaining as wide a number of pupilages as possible.
That's a really important issue. And as deputies know, there's a separate provision in the legislation intended to provide for the Legal Service Regulatory Authority to look at the whole area of legal education, what changes may need to be effected, what is necessary to ensure that doors are kept open, what's necessary to ensure that those who wish to become a member of either profession have access to do so, and again, that nothing occurs that impedes that. And there's very specific provisions in the legislation looking at our system of legal education has been run well, and this is where there has been evolution, both on behalf of the bar and the solicitor's profession, in the increased sophistication of the lectures and studies and training provided to people who wish to become either a solicitor or a barrister. That's the area where there has been change over the years. And I suppose maybe the competition between the Law Society and the King's Inns in the type of legal training that they provide has helped to contribute to ensuring that its excellence has improved over the years. I think that's an important thing. But there hasn't been an overarching examination of the provision of legal education in Ireland, whether it can be accessed generally or there's any difficulties that some sections of society have in accessing it, whether some structural changes that may be needed or required that could be considered, whether, for example, as happens in England, and I'm not personally sure that this is either desirable or necessary in Ireland because we're such a smaller jurisdiction, whether the universities should be licensed or have some remit in providing professional training for either profession, and before everyone gets overexcited and thinks this is something I'm advocating, it isn't necessarily anything I'm advocating, because I'm very familiar with the system in England. It's necessary because of the extent of the population. I think I know the Law Society tried an experiment of providing legal studies in Cork, and it didn't prove economically viable. So I'm not sure there's any necessity for anything of that nature. But I think it's a good idea that we have the Legal Service Regulatory Authority asked to just to do an overview of educational matters. And if I could say, Chairman, in that context, I very much value the work done by both the professional bodies in providing continuing legal education for the qualified members of both professions. And I want to particularly welcome one development, which is that I would have corresponded towards the end of last year with both the Law Society and the King's Inns, and asked them, because I think this is important as something that comes out, again, of the independent legal professionals in consultation with an independent judiciary, as opposed to it coming out of the Department of Justice. I invited them to consider the creation of a course for qualified barristers, stroke solicitors, in judicial training, a course that would allow for members of the legal profession who aspire to becoming judges in the future, or those who have no interest in becoming judges but who are regular advocates in the courts and would like to get a greater insight into the judicial function, how judges approach cases, the type of evidence that they believe is helpful in clarifying issues. I invited both the Law Society and the King's Inns to consider would they either individually or collaboratively consider establishing such a course. And I want to publicly welcome the positive response I've received from the King's Inns, who I understand are engaging in the consultative process with the judiciary with a view to such a course. It would be a course, as I understand it, that would be available as an option to practicing lawyers to participate in. And I think it would be very valuable if we moved on in the context of training. At the moment, you get judicial training after you've been appointed. I think it would be an extra valuable link in the chain if there was an opportunity for practicing lawyers who may consider at some stage in their career applying to the Judicial Appointments Board to be appointed to the courts. If they had some opportunity with I would very much hope, a substantial input from the judiciary into engaging in this type of a course, and I very much look forward to see how this matter develops.
Very progressive and fascinating. Okay, I think we're done on that, so I'll just move on here. Thank you to everybody. On Amendment 172, it's a new section. In the name of the Minister, the question is that the new section there inserted. Is that agreed? Agreed. Now, we're inserting a new section, so we must take out the other one, and the question is that Section 76 stand part of the bill. I expect it to be in the negative. Neil, that section is false. Okay, Section 77, Amendment 173. Amendment of this acceptance amendment involves the deletion of Section 77 of the bill. So it's a new section. I've already discussed with 172. Minister, to move.
I move.
Question is that this new section be there inserted. Is agreed?
Agreed.
And then that Section 77 stand part of the bill. This will be the negative.
Neil.
That Section 77 falls. Agreed?
Agreed.
Section 78 is Amendment 174 in the name of the Minister. Acceptance of this amendment involves the deletion of Section 78 of the bill. This is a new section. I discuss 172. Minister, to move.
I move.
The question is that the new section be there inserted. Agreed?
Agreed.
And then that Section 78 as stand part of the bill. This will be in the negative.
Neil.
That section falls in the current bill. Section 79, Amendment 175 in the name of the Minister. Acceptance of this amendment involves the deletion of Section 79 of the bill. It's a new section. I discuss 172. Minister, to move.
I move.
Question is the new section be there inserted. Is that agreed?
Agreed.
And then that Section 79 stand part of the bill, and that will be in the negative. Neil. That falls. Section 80 is Amendment 176 in the name of the Minister. It's a new section. I discuss at 172. And there's the question is that the new section be there inserted. Is that agreed? Agreed. Section 177 in the name of the Minister. Acceptance of this amendment involves the deletion of Section 80 of the bill. This is a new section. 177 to 184 inclusive related and will be discussed together. Minister, to move and discuss.
I so move, Chairman. Now, we're now dealing with amendment groupings 177 to 184, Chairman. Is that right? Part 9 has been extensively reworked, Part 9 of the bill, primarily to ensure operability and clarity, and to incorporate a number of practical suggestions that were made to me by persons with expertise in the legal costs arena after publication of the bill. Indeed, coming back to something Deputy McLaughlin said earlier, which I didn't respond to. He said there's nothing in this bill dealing with legal costs. There's an entire part of this bill dealing with legal costs and designed to ensure that legal costs are kept at an appropriate and reasonable level based on the work done, and that there's an independent oversight and a very clear structure in place to facilitate clients of the legal profession or to have adjudications on legal cost bills that they receive that they may think are excessive, or indeed where there's a court proceeding and one side is ordered to pay the other's costs, and the adjudication process to determine what the costs appropriate are that should be paid. Now, in order to make it easier for the committee in the context of dealing with this part, any section that is proposed for amendment is presented in its fully revised state rather than as a series of individual amendments. I will now set out what each section in Part 9 provides and what changes, if any, are proposed. Starting with amendment number 177, which refers to section 80. This is a standard interpretation section to describe and delimit key terminology in the part. It has been slightly reworked from the original for the sake of clarity. During the long consultation analysis period that followed publication of the bill, some new definitions, including those of disbursements and contentious business, were found to be necessary. These have been inserted into the text that we have today. Section 81 is the technical provision to enable the redesignation of the Taxing Master's Office as the Office of Legal Costs Adjudicators. This new office will have an increased capacity for making adjudications, will be headed by a Chief Legal Costs Adjudicator who will have certain core functions which I will outline as we go along. Section 82 is a key section in the bill, representing as it does the twin policy imperatives of transparency and modernisation. The new Chief Legal Costs Adjudicator will be obliged to keep a publicly examinable register of determinations. This register will bring to light both the decisions being made by legal cost adjudicators, the reasons for their decisions. It's my belief and expectation that this register will make a valuable contribution to competition in the legal services marketplace. As legal cost adjudications will be a quasi-judicial function within the court service apparatus, I believe it's appropriate that adjudications will be published and explained within reasonable limits, so as not to breach confidentiality rules or overburden the office with bureaucracy. Section 83 is new. It provides clarity around the long-standing policy intention that while the new office of the legal cost adjudicators will replace the current Taxing Master's Office, the status quo will continue in relation to county registrars and their existing and limited taxation functions. The only change in relation to county registrars is that in maintaining their existing functions, they will be required to keep a register of their determinations and will, in their own adjudications, be guided by the principles relating to legal costs set out in Schedule 1. Section 84 is a much improved upon Section 83 of the bill as published. This section provides that guidelines will be prepared by the Chief Legal Costs Adjudicator for the benefit of anyone making an application to the office, setting out how the process works, what is required, and so on. I should point out that the reference to the Minister for the Environment as one of the persons to be consulted on the guidelines comes about as a result of Ireland's obligations under the Aarhus Convention, which seeks to ensure that access to justice in environmental matters is not, and I quote, prohibitively expensive. Section 85 on the review of scales of fees is new. It came to my attention recently that Appendix W to the Rules of the Superior Courts, which sets out certain scales of fees in relation to specified legal services, is irregularly updated. I propose to provide that the Superior Court Rules Committee, whenever it considers it appropriate to do so, but at least every 2 years, to review and update Appendix W in line with the legal cost principles set out in Schedule 1 of the bill. Amendment 183 provides for a new Section 86, which, along with the unamended Sections 85 and 86 in the original, will help to modernise the operation of what is currently the Taxing Master's Office. The new office, the legal cost adjudicators, will be required to be run in a more business-like and transparent fashion within the framework of a strategic plan, an annual business plan, and an annual report to be laid before the Houses of the Oireachtas, together with the annual report of the Court Service. I have ensured since publication that the powers of the Minister to influence and approve strategic plans have been removed from the text of Section 86. They are now purely a matter for the legal cost adjudicator, the Chief Legal Cost Adjudicator, and the Chief Executive Officer of the Court Service. The final amendment in this grouping is Amendment number 184, which relates to Section 88. It provides for the substitution of the office of the legal cost adjudicators for the taxing master's office, makes provision for chief legal cost adjudicator and his or her terms of appointment, along with those of other legal cost adjudicators. The key amendment here is the deletion of previous references to bankruptcy and arrangements with creditors as a disqualification from holding office as a legal cost adjudicator. It's possible that I will, at the report stage, also revise the length of term of appointment for a legal cost adjudicator, which may not be entirely satisfactory. It currently stands at a 5-year term, which is non-renewable. Having reflected on that, I'm concerned that the term may be too short. I'm concerned that by making it non-renewable, that substantial good practice and expertise could be lost to that office and to the important work that's being undertaken, and that continuity has a particular and an important role to play. And I want to reflect on how we further enhance the office and address this issue. Circumstances in which I'm concerned that if someone is appointed to this office, it shouldn't necessarily, and is not necessarily in the public interest, be a lifetime appointment. I'm also concerned to ensure that the office is entirely independent, and there's no suggestion that the minister of the day or a minister who may be unhappy with some adjudication could in any way interfere with the workings of the office or exercise some discretion with regard to whether, if the appointment was for the 5-year period or longer, as to whether someone's appointment should be renewed. So we're giving some consideration as to how to best deal with this matter pending report stage.
Okay, let's go through them then. Nobody offering. We're dealing with 177 to 174 inclusive. We've discussed them all. The question is that on 177, that the new section there in itself, is that agreed?
Agreed.
That section 80 stand part of the bill. Negative, I think.
Neil?
Neil, that falls. Section 80 falls. Section 81, Amendment 178. It's a new section. I'll discuss with 177. Minister to move.
I move.
The question is that the new section there in itself, is that agreed?
Agreed.
Agreed. Now, we're putting a new section, so we have to put this question as Section 81 stand part of the bill. That's the negative.
Neil?
Neil, and that section falls. We've taken it out. Section 82, Amendment 179, in the name of the Minister. Acceptance of this amendment involves the deletion of Section 82 of the bill. This is a new section. I discuss 177. Minister to move.
I move.
Move. Question is the new section there on itself. Is that agreed?
Agreed.
Agreed. And then that Section 82 stand part of the bill. Negative.
That's Neil.
That's Neil. That falls. Section 83, all Section 82 falls. Section 83, Amendment 180 in the name of the Minister. And this involves the deletion of Section 83 of the bill. If we accept this, it's a new section. I discuss 177. Minister to move.
I move.
The new section stand part be there in itself. Is that agreed?
Agreed.
Agreed. And that Section 83 stand part of the bill.
It's Neil.
Neil. That's removed. That falls. Taking out the old section. Section 84. Already discussed in 177. This Amendment 181 in the name of the Minister. And acceptance of this involves the deletion of Section 84 of the bill. It's a new section again. The Minister to move.
I move.
That the new question is new section there and still that agreed. And that Section 84 stand part of the bill.
That's Neil.
That's Neil. That's the old section is taken out. Section 85. It's a Amendment 182 in the name of the Minister. It's a new section. Already discussed 177. Question is the new section there and still that agreed.
Agreed.
Agreed. Amendment 183 in the name of the Minister, new section. I discussed 177. Questions, new section there and set. That agreed?
Agreed.
Question is Section 85 stand part of the bill. Agreed?
Agreed.
Agreed. Section 86. That's Section 86 stand part of the bill. Agreed? Section 87. That's Section 87 stand part of the bill. Agreed?
Agreed.
Section 88. That's already discussed 177. It's Amendment 184 in the name of the Minister, and accepts this involves the deletion of Section 88 of the bill. And the question is that the new section be there inserted.
Agreed.
Minister to move, sorry.
I move.
Move and
agreed.
the new section be there inserted. That's agreed. And then we're taking out the old section. The Section 88 stand part of the bill.
Neil.
Neil. And that's taken out. Section 89. That's section questions to Section 89 stand part of the bill. Agreed?
Agreed.
Section 90. Now, this is Amendment 185. Acceptance of this amendment involves the deletion of Section 90 of the bill. It's a new section. 185 to 188 inclusive are related. 189 is a physical alternative to 188. 185 to 189 inclusive will be discussed together. Minister to move 185.
I move, Chairman. Section 89 of the published bill is unamended except for a tiny typographical change. It continues the existing prohibition on solicitors charging fees based on percentages of damages due to the client, and it applies to barristers in addition. It also prohibits the automatic deduction of legal costs from damages or other awards. An innovation of this bill is the prohibition on the charging by barristers of legal costs that are based on crude calculations of the value of junior counsel as a 2/3 or other proportion of senior counsel's fees.
Sorry, what section, Young Minister? Section?
On section 89.
We've covered that. We've gone past that. We're on section 90 at this stage.
Sorry, Chairman.
Describing the section.
I was just describing. Right, we're on amendment. Yes, no, I was just describing it as an introduction to, to where I'm going.
Yeah.
Amendment number 185 refers to section 90. It has been revised by the drafters to improve the flow and clarity of the text. It incorporates the best aspects of the existing section 68 of the Solicitors Amendment Act 1994 in relation to the obligation on solicitors to provide their clients with written fees estimates, and makes significant improvements upon it. This is a key and innovative section in the bill as regards legal costs transparency, and it will also apply for the first time to barristers. It sets out that legal practitioners will have to provide clients with a written legal cost notice written in clear language. It's likely to be easily understood by the client. Such notice will set out either the legal cost that will be incurred, or, if that is initially impossible to know due to the presence of variables, it will set out the basis on which legal costs are to be calculated. Factors such as the stages in the litigation process, costs of outside expertise, financial consequences for the client of withdrawing or losing the case are all to be covered where relevant. In addition, the legal practitioner will be under an obligation to inform the client of any emergent factor that would significantly add to the estimated costs for the client, and a new notice will have to be provided. A 10-day cooling-off period is allowed, and as an added protection for clients, legal practitioners may not engage counsel, expert witnesses or other service providers without first gaining confirmation from the client. Legal practitioners will also be obliged to provide any clarifications in relation to the notice whenever so requested. Section 91 allows legal practitioners and their clients to make agreements as to fees for services. This is a continuation of the status quo. The text has been enhanced since publication to make it clear that such agreements may still be amenable to adjudication by the legal cost adjudicator where appropriate. Section 92 is another transparency-related section. It sets out in detail all the constituent items to be included by a legal practitioner in the final bill of costs provided to the client. It will describe in the form of an itemised statement the legal services provided, the time spent and other relevant factors. It has been enhanced since publication to ensure that any fee-related agreements between the legal practitioner and the client are set out clearly in writing. It also sets out the preliminary steps in relation to the communication and resolution of any disputed items, and it allows barristers to provide their bills of costs through the solicitor concerned, who shall provide it to the client immediately upon receipt. Section 93 places an obligation on legal practitioners to attempt to resolve disputes around legal costs with their clients before resorting to making a formal application to the legal cost adjudicator. This is in keeping with the Bill's desire to encourage mediation and other informal resolution avenues. In support of this, the section also provides a new clock-stopping mechanism whereby the time taken in attempting to resolve a dispute is disregarded within the time frame for making an application to the legal cost adjudicator. In relation to opposition amendment number 189, Chairman, if I could address that. I note Deputy Collins' absence, but perhaps I'll nevertheless address it. Deputy Collins' proposed amendment is based on Section 76 of the Finance Act 1982, which inserted a new subsection, Section 5(4)(a) into the VAT Act 1972. It provides that VAT is payable on fees for services even where the supplier of the service is not legally entitled to recover payment of the fees. The effect of it is that VAT has been payable on barristers' fees since September 1982. As this part of the bill's amendments do not impinge on the VAT regime, I am not willing to accept the Deputy's amendment. As I understand it, because barristers are not legally entitled to sue for fees payable to them, the Revenue Commissioners have accepted in practice that VAT on barristers' fees is payable upon receipt of the fee by the barrister rather than by reference to the date when the fee note is issued to an instructing solicitor. I have received submissions from interested parties asking me to ensure the Revenue Commissioners continue to treat barristers' fees in this way in the event that a provision is inserted in the bill to allow them to sue for their fees. I do not, as Minister for Justice, have the jurisdiction to dictate to Revenue how they should treat any category of taxpayer. Moreover, the Bill does not yet provide that barristers can sue for their fees, so Amendment 189 would be premature and may yet be relevant. While a provision to recover barristers' fees is being considered for insertion at report stage, the appropriate wording has not yet been found in conjunction with advisory and parliamentary counsel. I would also point out that the legislation the Deputy refers to only places an obligation on barristers to pay the VAT, does not provide for the specific treatment of the VAT concerned. These circumstances, the amendment will not do what the Deputy presumably wishes it to achieve. But quite clearly, if we are to have, in the context of provisions in the Bill that allows direct access by members of the public to members of the bar for non-contentious business, and there are other possibilities depending on the outcome of the consultative process. In fairness to barristers, it will be important that there is a clear provision to ensure that should a barrister undertake work on behalf of a member of the public and not be paid for that work in the absence of a solicitor being part of the relationship, that the barrister can properly sue to recover fees properly due to the barrister. And indeed, if the legislation were not to adequately address that issue, it would leave a very major lacuna in the legislation that would be inappropriate.
Okay, nobody offering. Okay, I'll put the question then. That section, the new section be there in Circular 185. Is that agreed? Agreed. The question is that section 90 stand part of the bill.
Neil.
That whole section is taken out. Section 91, already discussed 185, Amendment 186 we're on, it's a new section. And the question is the new section there in Circular agreed? Agreed. That section 91 stand part of the bill. Neil. That's all sections taken out. Section 92, Amendment 187. It's a new section we're inserting here. Already discussed 185. Question is a new section there inserted. Minister to move.
I move, Chairman.
Question is new section there inserted. Agreed?
Agreed.
Agreed. That's section 92 stand part of the bill.
Neil.
And we're taking out the old section. That section falls. The next one is amendment number 188. It's a new section. We're inserting here. Already discussed 185. Minister to move.
I move.
Question is that the new section is inserted. Is that agreed?
Agreed.
189 cannot be moved. And the question now is that section 93 stand part of the bill.
Agreed.
No.
Oh, Neil.
That actually falls. I think
Very well up to that.
there you go. And I think now it's a good time to maybe a natural time to break.
I think we're making good progress. Can we just continue and see this through?
No, it's not fair on the staff. It's actually really not fair on the staff. There's a bit to go yet.
Fair enough.
You know, so I think there's a lot to go yet actually. So I think we'll.
How long do you estimate it would take to go through it? There's no objections to the remaining amendments. It's just a matter. If the Minister was agreeable to shorten his presentations, we could quickly go through them.
Well, no, in fairness, we did agree we break at 1 until 2. So we'll break.
Seriously, like, I'm not sorry, I don't want to be belligerent, but like,
I'm sorry.
Would an hour, 20 minutes, half an hour take it home?
I'm sorry. We're stopping now. It's not fair on the staff. They need a break too.
Oh, no, if it's about staff, I have no objections, absolutely not.
We're
But I
going to
just
take a
think
break for an hour.
it might actually benefit the staff for us
Back
to
at
wrap
2
up
o'clock.
early too,
Thank you.
So, okay. That's back at 2?
2 o'clock.
Okay.
Could
We reconvene.
I make?